Hello, my name is Larry Cohan. While litigating our clients' cases here at Annapol Schwartz over the last 24 years, I've heard one question from nearly all of our clients about their representation. How soon will my case get resolved? A complete answer to this question can be somewhat complicated. No two cases are exactly alike, so the answer might differ from case to case. However, there are certain fundamental steps that are taken in every civil case, and there is a fairly typical pattern for the timeline which each case will follow. Over the next few minutes, I'm going to lay out for you a timeline for a general case, briefly discussing each of the phases of litigation and what roles each party will play during that time. The breakdown that follows applies to cases involving medical malpractice, products liability, toxic exposures, pharmaceutical cases, and many other types of civil cases. A case can be broken down into 10 phases and described as follows. 1, the initial meeting. 2, the client questionnaire. 3, internal investigation. 4, the complaint. 5, discovery. 6, the depositions. 7, the expert witnesses. 8, pretrial preparation. 9, the trial. And 10, the appeal. Now let me take a moment with each phase and I'll provide some examples. Number 1, the initial meeting. Our first meeting is sometimes referred to as the initial write-up. At this time, you will be interviewed by an attorney or paralegal who will take detailed notes and learn from you all of the available information which you have in your possession. Our write-up form is a lengthy document which looks something like this. Number 2, the client's questionnaire. In many cases, we ask our clients to complete a detailed questionnaire, which is unique to their type of case. Sometimes we will ask you to do this on your own time. This may include a work history, a medical chronology, or other information that we want you to take time to think about. Rest assured that we would only ask you for this information if we feel it is absolutely necessary. So we ask you to complete the questionnaire for us as promptly as possible. Please don't worry about your writing or the presentation of what you give to us. We just want to have the benefit of all of the information that's available to you. Our office conducts a comprehensive investigation into every case. We would not pursue your case, or any case for that matter, unless we were satisfied that we had all of the necessary information and that we were in a position to meet our burden of proof when your case comes to trial. Our investigation might include obtaining medical records, police reports, public documents under the Freedom of Information Act, interviews of witnesses, preliminary feedback from expert witnesses, research into the law, and much more. Depending upon the complexity of your case, this investigation could take anywhere from several weeks up to several months. If your case requires expert opinion, we are dependent upon technical, scientific, and medical experts to review materials and provide us with reports. Please be patient while we complete this all-important process. Number 4, the complaint. If our investigation leads us to the conclusion that your case is factually and legally sound, we will begin the preparation of your complaint. The lawyers, paralegals, and support staff working on your case will meticulously prepare your complaint and all the necessary paperwork for filing with the court. Your complaint will be filed in a timely manner long before any statute of limitations or any other deadline approaches, and then it will be served upon the defendants that are named in your case. Then the long, hard work will begin. Number 5, discovery. We are now probably several months after your initial interview with us, and the discovery phase is the longest and most difficult phase of your case. Discovery is the legal term that covers all of the work that the lawyers do to prepare your case, including the gathering of evidence, exchanging of information, and uncovering of the truth so that we can prepare for trial. This phase includes the exchange of interrogatories, which both sides exchange and answer. It also includes an exchange of the request for production of documents, which requires each side to provide the other with all documents that they have or can obtain which are relevant to the case. There are many discovery tools, including subpoenas, requests for admission, motions, filings with the court, and much more, all of which we will utilize to the fullest extent necessary. Phase 6, depositions. After taking several months to exchange all of the written materials, we then embark on the deposition process. Every party, every witness, and in some cases, the expert witnesses, will need to be deposed. This is when the witnesses are examined and cross-examined by the lawyers with a stenographer or court reporter present, and transcripts are created of that testimony for use at trial. Rest assured that you will be well prepared by us for your own deposition, and we will aggressively pursue the depositions of all of the relevant fact witnesses, the defendants, and anyone else that can help us prove your case. This is what a deposition transcript looks like. Phase 7, experts. Depending upon the number of witnesses that need to be deposed, that process can take several months. During that time, and in fact at any time during the litigation, we will be consulting with expert witnesses that have specialized knowledge in the subject matter of your case. They will prepare detailed reports discussing the issues of negligence, liability, and damages. The parties will exchange those reports, and ultimately, the experts will testify at the time of trial. This process can be time-consuming, taking many months, as well as expensive, but it is critical in all but the most straightforward of cases. Phase 8, pretrial preparation. Depending upon the county in which your case is filed, the court will issue a trial date, usually anywhere from 1.5 to 2.5 years after your complaint is filed. The parties have little say over the timing of the trial date, but our policy here at Annapol Schwartz is to be ready when the court says that the case is to be tried. Once we get a trial date, you will be notified and we will begin preparations. All depositions will be abstracted, witnesses contacted, demonstrative evidence prepared, and appropriate filings with the court will be completed. Unfortunately, the court or our adversaries often postpone or delay trial dates for a multitude of reasons. As your lawyers, we will aggressively attempt to maintain all trial dates, but we do ask your patience because delays are a harsh reality in our legal system. Number 9, the trial. After receiving the notice from the court and preparing, we will take your case to trial. Our experienced trial attorneys will have you well prepared, will have all of the witnesses lined up, and will present your case to the jury in a compelling and effective manner. Trial can last anywhere from several days up to several weeks, and will require a commitment of time and energy on your part. It is always possible that your case might settle. Those decisions are made by the defendants and their insurance company, and we simply need to be prepared to discuss settlement when the issue is either raised by the court or our adversary. Settlement rarely occurs before the case is scheduled for trial. In the more complex cases, such as medical malpractice and products liability, settlement often does not occur at all, or at least until the trial is well underway. Number 10, the appeal. We always need to be prepared for our case to go to verdict, and, when we are successful, to be appealed by the defendant. Defendants can appeal verdicts for a multitude of reasons and can ultimately delay the payment of any verdict for anywhere from 1 to 2 years. Of course, a case that is settled is paid immediately without the right of appeal or delay. What I've just described for you over the last several minutes is a timeline for most cases which runs anywhere from 1.5 to 2.5 years, sometimes even longer. If you have any additional specific questions about your case, don't hesitate to ask us, and I'm sure we can fill in the gaps. Some things are unpredictable, and litigation is like a roller coaster ride with many emotional ups and downs. Please be patient and work with us as we obtain the best possible recovery for you. Thank you.